Good afternoon. Thank you for joining us on The Money. And once again, we're talking about the subject of marriage and finances. Now, the focus is what happens post the marriage. Marriage in itself can be very difficult. But imagine if we have to go through divorce. What are the implications beyond just having a divorce? What about maintenance? What about maintenance for the kids? What about the assets? What about spousal maintenance? And today, we're going to focus specifically on spousal maintenance. And with me today, I have Phumelelo Simelane. Ngiyabonga Baba. Thank you very much for joining me. But tell me a little bit about Phumelelo.
No, thank you for having me. Yeah, my name is Phumelelo Simelane. I currently practice and run the firm of Simelane Attorneys. We are situated in Sandton, Rivonia. I have a keen interest in family law, which is what we are discussing today, and commercial and corporate other work. But my keen interest really is divorce. I found out the other day that my true caller name is Phumelelo Divorce Attorney.
Wow.
So I do a lot of the divorce work. I usually act for mothers or women, and we run quite a successful, I must say, dispute resolution practice, primarily focusing, as I said, to family law, corporate, and others type of work.
Right.
Yes.
Before we even land there, just land me here. Let's talk about marriage first, right? Before the divorce, before maintenance, before we even get there, the types of marriage regimes, and in brief, what impact do they have on your finances?
So in South Africa, you get married in three ways. The first way is unfortunately the default position, which is what's called incommunicable property.
Yes.
What is yours is mine.
Yes.
What is mine is yours. Yeah. So this also includes all of the assets and all of the liabilities. Yeah. Usually we don't want this one because what you do on the other side affects this side. So if we have a gambling problem and they come to fetch a house, or they come to attach a TV, they're attaching from the joint estate. So that's an incommunicable property marriage. We're at an age now where no one should be married in communicable property.
Wow.
It's just, there's too much knowledge around it, right? Then there's one that's called a out of communicable property, excluding the accrual, which basically means there are two distinctive estates. You can do with what you want to do with your assets and your liabilities. Okay. They'll never affect your party, the other party, vice versa. So this one is very good because what you do on the other side doesn't affect us. We're able to mitigate the risk, and we're able to ensure that at least, ourselves are protected financially, our kids are protected financially. And the last one is with the accrual, which basically means whatever your commencement value is at the time of the marriage is then comes into the end at the end of the marriage. In South Africa, marriage is ended by two ways: divorce or death. Okay. So we then do a calculation. Remember, lawyers are not good with math. So the simple calculation is as follows. If you started at 0 and I started at 0, at death or divorce, you're worth 100 Rand, I'm worth 50 Rand. Yes. We're then entitled to the half difference of the growth accrual, which basically means 100 minus 50 gets to 50 divided by 2 gets to 25 Rand. So the spouse whose estate is accrued the least has an in-law 25 Rand that he can enforce. Entitlement in law that they can get. It's not in assets. So it doesn't mean you have you can exchange it for a house or a car. Yes. It's purely monetary, and you have 25 Rand in law that you can actually enforce against the other party.
Right. But things happen. It's the dealing I'm with it in the case, and now we're looking at it with scared eyes. Yes. Now we get to the stage where it says, hey, no. You go your way, I go my way. But then the complication then comes to issues around maintenance. The topic for today that I want us to focus on specifically is around spousal maintenance, right? Just in brief, what is spousal maintenance and what are the different types of spousal maintenances that we find in law in South Africa or generally?
So spousal maintenance is basically the obligation a party has to upkeep or for upkeep of the other party with lesser financial means, right? Yes. So the easiest way to understand it is to explain the different types of spousal maintenance.
Please do.
So we have a maintenance that's called rehabilitative maintenance. So this is essentially to try and get the party back up on their feet.
Right.
Usually they were the housewives. They're taking care of the kids. They were not allowed to do work. The husbands are saying, we want you at the house. You must always be available. So that one is called rehabilitative. So we're trying to rehabilitate them and get them to a point where they're able to stand on their own 2 feet.
Hang on, but it can also happen to be a house husband, right?
Of course, of
so
course.
the spouse means
Yeah,
he
yes,
or
yes,
her
yes.
or
Of course. Sorry,
yes.
I should have clarified.
Okay.
I should have
Right.
clarified it. So it's not only entitled to men. It's entitled to both men, female. It's entitled to both, even same-sex civil
Same-sex,
union,
yes.
recognition of the Customary Marriages Act. So it's across the board.
Across all-
Its aim is to just get the party who had lesser financial means to a point where they are able to stand for themselves.
Yeah.
And that's why it's never lifelong or in perpetuity.
right.
It's 3 years, it's 4 years. We have to look at it case by case.
So there's an end time.
There's an end time, yes, there's an
defined
allocate time. Yes,
yeah?
that's correct. So usually they'll say 3 years, 4 years, 5 years,
Right.
but I've rarely seen anything about 5 years. It's really just to get the spouse into a position where they're able to fend for themselves. Whichever it is, it might be female, might be male,
Yeah.
whichever spouse was not in financial control or power. So that's what you get called rehabilitative maintenance.
Right. Rehabilitative maintenance.
Then you get what's called lifelong maintenance or maintenance in perpetuity, which is it's a very tricky one, but it's difficult to prove. So this is usually the one where we've been married for 40 years. I'm at a point where I don't have any education. I'm unemployable.
Wow.
I've taken care of the kids. I've raised the kids. I've been the house executive.
Yes.
I want maintenance in perpetuity, meaning I want maintenance up until I die, up until my demise, or up until I remarry.
Hang on. So it ends if I die
Yes.
or if I remarry.
Yes,
right?
yes.
So that's
yes.
when
that's when
the
the
perpetual-
obligation. That's when the obligation is distinguished.
Right.
So up until I remarry, and then I die.
All right.
But again, we're finding cases where people have been divorced, people have found partners, lifelong partners, but they're not getting married.
And that still continues.
Because
Yeah,
obviously you would distinguish that monthly obligation. There's a way to deal with it, but that's usually the scenario. But like I said, we'd have to look at the age, the financial positioning of both parties to be able to even think about making that claim.
Okay. The third one?
So there's a third one. It's not really used in South Africa, but it's called token maintenance. It's usually reserving a right where you say you want R1, right? But you're not sure what the future holds for you. So you're just giving yourself an opportunity or a space where if the circumstances would change so drastically, you'd be allowed to approach the court again to say, can I at least have 5,000 Rand maintenance? We don't see it a lot in practice, but it is there.
But it does exist.
It does exist. The ones, so then the last ones, which is what's called a Rule 43 in the High Court. So if we're litigating in the High Court, it's called a Rule 43. It's called interim maintenance. If you are litigating in the lower court, which is the regional court, it's called the Rule 58 or Rule 53. I might be mixing it up. But the whole purpose of it is interim maintenance. So divorces generally take time.
Okay.
And what we have seen is usually, the people with the financial muscles are the husband.
Yes.
So you can't litigate against someone who has what we call an unending financial pockets, who can bury you with attorneys, bury you with advocates, who can threaten to say, if you leave here, where will you stay? I'm going to take the kids out of school. They go. Do you understand the threats? It's like I said. It happens both sides, but usually the case is more husband than wife. So the court developed something beautiful, which is this Rule 43, which is interim maintenance pending the divorce outcome. So if we know that a divorce can take 5 to 6 years, and I know as a party to the divorce that I won't manage for 5 to 6 years without his financial support, I instruct my attorneys for a Rule 43. Yes, it does delve with other things like kids and stuff, but on the financial side, it's spousal maintenance. So we are saying to the court, please order this man to pay us 30,000 Rand a month up until the divorce is finalized. Please allow this man to make a certain vehicle available to us I still want to drive my Porsche
Yes.
for the next 5 years.
Right.
Not next 5 years, up until the divorce is finalized.
Yes.
The tires must be maintained. It must be serviced.
Wow.
Petrol. He must continue paying the mortgage, bond, rates, levies.
Yes.
So this is all dealt with in a Rule 43. And the big facet upon a Rule 43 is also, remember, you, especially if you're in a position where you're a housewife, house husband, you're looking after the kids, you don't have funds to litigate against your husband on the same footing. So this is also where you ask for a contribution towards your legal costs.
Can I challenge that Rule 43 or Rule 58 in a case of a lower court?
Of course.
Can I, as a house husband, say, look, the magistrate, you've offered me 30 cents, but actually I'm looking for 50 cents? Or can I say, as a working husband, no, magistrate, this person is not entitled to even a penny out of this based on the Rule 43. What are the grounds of granting a Rule 43 and can it be challenged?
Of course. So usually a Rule 43, I should have explained this, because the divorce takes 5 years, a Rule 43 was specifically enacted to deal with it now. So if we do a Rule 43, we're in court now, quicker, in the next 3 months, 6 months, because we can't be in court until 2030.
Yes.
You won't survive. Right. So when you bring a Rule 43 application, you need to prove to the court that you are in his financial need. You are his dependent, so to speak. He pays for the car. He pays for the house. So you need to make out and set out a case to the court to say, court, I am destitute.
Yes.
He needs to continue paying for the kids because he's been doing this.
Yes.
So the aim of a Rule 43 is to actually maintain the status quo up until we divorced. So of course it can be challenged, and this is where we need to be a bit more realistic and practical with clients.
Yes.
If you are driving a Polo, you can't now come and say you want a Porsche.
Out of the Rule 43.
Out of the Rule 43. That's when judges start saying we're being unreasonable. We must advise clients properly. But also, same breath, if you, during the duration of the marriage, were giving me 30,000 Rand a month to maintain the home, you can't now come and say 10,000 Rand.
All right.
Do you understand? But ultimately the decision rests with the court. The courts look at the age of the parties. They'll say, no, man, why don't you go get a job, for example?
Okay.
You are in a position to obtain employment. You are employable. They'll look at the pay disparity. Yes, you might be earning a salary, but you're earning 10,000 Rand versus someone who brings home 500,000 Rand a month.
Okay.
There's a pay disparity.
Yeah.
Right? So these are some of the circumstances the courts do look into.
So can this thing be abused? For instance, yes, you got a Rule 43 granted, and we say perhaps a reasonable time should be around about 5 years. Can I drag this for the next 10 years as somebody who's receiving the spousal maintenance out of the Rule 43? Does it ever happen?
Yes, of course, they abuse it. So usually when you're in recipient of a Rule 43 order, you'd want to milk this order as far as you can.
Wow.
Right? So let me separate it like this. A Rule 43 is actually called an interlocutory application, which means it's an application, it's something between something bigger. Remember the big thing, we're getting divorced.
It's divorce.
That's the big thing. That's the main action. The Rule 43 is just there in the middle, right? So what often happens is once a person has a Rule 43, they start dragging their feet. So the main divorce takes time. But there are measures and there are ways where we can actually push the main divorce so we get to a point where the Rule 43 is distinguished. Because the Rule 43 will only be distinguished once there's a final divorce order.
Can't I go to court, for instance, and say, hang on, Madam is dragging this thing unnecessarily so, and it's simply because she's
enjoying the benefits of the Rule 43.
Is there any way that I can then approach the court for relief?
Yes.
And if I can, what are the grounds?
So two ways. In the main action, the divorce action, let's say the madam, as you put it, needs to produce documents so we can go on to the next stage. But they're not producing documents. They're diving, they're running away. You bring an application to compel. So that means they must produce the document within 10 days. And if they don't, you can actually strike out their defense or you can move closer to the date. So yes, there are ways. On the Rule 43 side, it can happen that you're running a thriving business.
Yes.
All of a sudden COVID hit. You saw this a lot with COVID.
Yes.
you're now applying for funds to keep, you're making zero.
Yes.
So then you bring what's called a Rule 43.6 to tell the court, I understand there's an order that obligates me to make payment per month. But looking at the financial
circumstances now,
there's been an exceptional change in my circumstances. Allow me to reduce, or allow me to discharge, or look at me now. I was making 100,000, but I'm making R1. I can't even fend for myself. So yes, there are ways to go about it. Yes.
So this Rule 43, if I understand perfectly, can also be challenged. It's not a perpetual arrangement, right?
Yes.
As you've said, it's an interim arrangement pending, you said interlocutory.
Yes.
Pending the bigger case, this is what you can get.
Yes.
And how often do we see that in court? Does it
It happens all the time. It happens all the time. So the only time you won't see a Rule 43 or when it won't be brought out is when both parties are financially savvy or are financially capacitated.
All right.
Because then there's no need for me to bring a Rule 43. But remember, I'm primarily speaking about a Rule 43 against the backdrop of spousal maintenance.
Just spousal maintenance.
Yeah, it deals with other things. It deals with kids, for example. You've now moved out of the house. How are we going to sort out the kids? Are you going to come see the kids every alternate weekend? Are you going to come see the kids holidays, birthdays, Father's Day, Mother's Day? It also deals with issues like that. And like I said, legal contribution. It's a big one. Yes, you might get an order that says pay me 15,000 a month, but how am I going to fund my litigation going forward in the main action? Because it's expensive, and that's why that's when clients or applicants in the Rule 43 often ask for 100,000 rand deposit towards, so they can pay their own attorney, so they can litigate with you on the same footing. If you can pay your attorney 100,000, I should be able to pay my attorney 100,000 rand, so we can
litigate against me, right?
In the same,
ladies and gents, that's where we get into where you will actually get money to litigate against your spouse under Rule 43.
Yeah, so the court wants to put both parties in a similar position. Otherwise, there's a big discourse, right? There's one who can afford a attorney and advocate in Sandton. Then there's one who simply can't even who simply can't afford to do anything. Who can't pay an attorney, can't pay an advocate. They are often left destitute. They must approach legal clinics or legal aid. When you are litigating against someone who can afford the bigger firms, the big five in Sandton, as we say.
I'm interested still in the perpetual one. Circumstances change, right? What are the rules in terms of changing the perpetual spousal maintenance?
So perpetual spousal maintenance, again, it's difficult to prove. But if you, as being awarded a perpetual maintenance, right, and you as the other party would want to distinguish or extinguish that, you'd have to show the court exceptional circumstances have changed on your side. It's usually maybe loss of income, maybe you're in a position where you are hospitalized, you are unable to function anymore. I want to make the example and say you've lost a limb. But you'd have to show exceptional circumstances to the court that you are unable anymore to do this, and then you'd have to bring what's called a variation application, where you are saying to the court, yes, it's a divorce order. It says I must pay X up until I remarry or or my demise. But court, I can no longer wait for that. I'm in a situation right now where, yes, I was earning 100, I'm earning 1,000 rand, I'm on pension, I've lost my business, I've been liquidated, for example. My businesses have been liquidated. I personally have been sequestrated. I can't manage to do this. And the courts would then often look at it and see and maybe grant and distinguish the order.
All right. Simelane, let's look at different scenarios. Initially, when we started the conversation, we said there's different types of marriage regimes and marriage contracts, right? And all these have different impacts in terms of finances. Can we link spousal maintenance to any particular, for instance, if we married out of community of property without any accrual, right? Can I still sue for spousal maintenance?
Yes, of course.
What are the circumstances? What needs to be proved? What are the cases in there?
100%. So remember, spousal maintenance flows directly from the obligations of the Divorce Act and the Matrimonial Property Act. It has nothing to do with whether how we are married or how our marriage is constituted.
Okay.
Nothing. It flows from the obligation. So if there was an obligation during our marriage where
so almost like dependent. If I'm dependent
yes,
on,
there was some sort of dependency,
irrespective of what type of marriage, right?
Yes.
I can still sue for spousal maintenance and get it through, irrespective of how we were married.
So you end up finding cases where there are no issues in dispute patrimonially, meaning there's no issues around who owns the house, who owns the car.
Yeah.
In fact, we are in agreement with the kids. The kids can stay with you, they can stay with me. I'll pay for the kids 100%. The only issue that's left is spousal maintenance.
Wow.
So spousal maintenance does not flow from the marriage that's been constituted or the marital regime. Nothing.
Yes.
Now, it has nothing to do with that. It's like its own life. It's its own person that springs up when it needs to spring up.
But then, is there any cutoff? For instance, we started this divorce process. There's a bit of a Rule 43, and then we get to a space where now we divorced, and at that particular point, there's no proof that I might need spousal maintenance. But then in the short term, then I need maintenance. Can I go back retrospectively and sue for spousal maintenance? Or is there, it's done, it's finished, it's cut off, you're on your own?
So I'll explain it in two times, right? In two ways. So let's say we settle.
Yes.
Which basically means we are settling the divorce as a whole. We are in agreement that we are going to sign and settle and say, the kids go with you, you take the blue couch, I take the red couch, etc., right? Yes. And in that agreement, we say no spousal maintenance is claimable by either party. Yes. You cannot go retrospectively down the line and claim for maintenance. Because now they would say you agreed that there was no spousal maintenance and it would be claimable.
And post the divorce order, let's say for instance there's an order already, it's not a settlement, it's not something that we've agreed, right? I've gone to court, he didn't pitch up, and eventually I get almost like a default judgment out of it, right? But the default judgment does not include the spouse. Can I go back and say, hey, I want to appeal this, I want to include then the spousal maintenance?
So you would have to make out and set out a case for variation, which is a very high threshold. You would have to essentially convince the court that at that point, I was ill-advised. I was not aware that I could claim spousal maintenance. It has only come to my attention now. Court, can we include a provision in the order of spousal maintenance? But like I said, that is a very high bar to meet.
Just in closing, what are the pitfalls that we should look for either of the party in terms of the spousal maintenance? What are the requirements? What are the pitfalls? What are the things that we should be aware of before asking or paying for spousal maintenance?
So I think, firstly, in any divorce situation, we need to try and approach it amicably as possible. It's difficult. You would swear when you are litigating that these people once professed their love for each other because things have changed so much that at odds. You would swear. So I would say, especially with the minor kids involved, I would say let's start with trying to amicably resolve the divorce through a roundtable discussion, which is what attorneys usually try to do. Because remember, once you go full guns blazing, your legal bill goes up, the children are affected. The first thing that I would say we must try and look for, try and curtail the issues in dispute. Sometimes we're not fighting over kids. There's no fight over kids. But because of pride, and I want to show you, we're not fighting over kids, but you know that the mother or the father was always responsible for the kids. Why must we start now, right? So that's the first one. And then I would say, in terms of Rule 43, what you need to look out for is pay disparity. It's easy to bring a Rule 43 application. We can do it now. We can do it tomorrow. But we need to have fact on our side. We need to really look deep into our own finances and not dream of amounts. Yes, a judge once made a remark to my client to say, this is not a shopping list. A Rule 43 is not a shopping list. It's to try to just maintain the reasonable status quo pending the divorce action. So I would say we must be very realistic with ourselves I think the last thing that I would want to touch on is what happens when a Rule 43 is not complied with. Yes. Because remember, Rule 43 is the court order. This is when, if you don't comply with the Rule 43 and it says you need to pay 15,000 and you've not paid 15,000,
yes,
and this is when contempt of court comes in.
So you're in contempt of court because you broke the court order.
You broke the Rule 43 order, and that's when usually now there's an application for contempt. And to prove contempt is very easy. You need to show that there's a Rule 43 order. You know the Rule 43 order, you've seen it, and there's been non-compliance, you haven't paid. Then the onus shifts from me to you. You must then prove to the court that, no, court, I was not in willful default because my business circumstances changed. Maybe I was not aware of the order or something, but that's what parties must want. Once there's a Rule 43 order, even Rule 58 order, it is fully legally enforceable.
Absolutely.
It does not matter if it's the High Court, does not matter if it's the
Magistrate Court. Thank you, Baba. Uthando is a good thing. Weddings, marriages, absolutely fantastic. But remember, all of these have a financial implication. Go there, get yourself armed. Spousal maintenance is a real thing. Find out more about it. Siyabonga.